Evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have many issues to discuss on tonight's program. I want to begin by welcoming all of our viewers who are joining us on television from West Coast Berbice, region number 5. Welcome to another program of Issues in the News, to our viewers on television who are joining us on the east bank of the Berbice River, New Amsterdam, Kanji, and of course along the Quarantine Coast and beyond. Welcome to another program of Issues in the News, and last but not least, to our viewers, the tens of thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, and beyond. Welcome to another program of Issues in the News. Please remember to press that share button on your phone, on your computer, on your iPad, on your laptop, or whatever device you're looking at this program with or on. Press that share button so that this program can be viewed by your friends, by your followers, and so that we can have the widest possible audience. So share this live, press that share button on your phone so that we can share this program wide and far, and your friends and followers can join us in this tonight's discussion. Soma Bipat Muna Moonshine Matadial, Sunita Babulal, Mohammed Zakir Yusuf, Asha Bakas, and so many of you. Welcome to another program of Issues in the News. And also remember to share your comments, pose your questions in the comment section so that we can have an interactive discussion. I normally say that, but sometimes when the program gets started, you get so engrossed in the presentation that I rarely get an opportunity to look at the comment section. People are beginning to ask me about Rickford, Burke, and when he's coming to Guyana. You have seen the government's statement on Rickford, Burke. The matter is now receiving the attention of the U.S. Justice Department, the U.S. State Department, the Federal Bureau of Investigations, and a series of important functionaries within the U.S. government. The government of Guyana is following the protocols as we have been invited to do, and the formal complaints have been submitted. We have a team of attorneys at law in the United States of America who will be following up with the different agencies, while our ambassador in the U.S. will also be engaging, and of course here in Guyana we will be liaising with the U.S. Embassy here. So a process has been activated, and let us await the process to unfold. People are asking me if I'm looking at Mr. Burke and what he's saying. My lawyers are also reviewing what Burke is saying. I have neither the time, the energy, nor the inclination to listen to what Burke has to say. But let's just be patient, get your popcorn, get your Coca-Cola, and just look at how this will unfold. That is all I want to say. The gods say that whom they wish to destroy, they first make mad. Well, apparently that saying is also being seen as manifesting in the form of Burke's behavior. So the least I say about Burke, the better. Let the process run its course, and we will see who will have the last say in the matter. All I will say is that the legal process may be slow, but it is sure. The arms of the law are long, and they can reach in very far and deep recesses to bring those who are considered fugitives to justice. And I'll leave it there. So let's start. You would have seen in the public domain a lot being reported in the press in relation to the registration of a foreign arbitral award in the courts of our country. And perhaps I owe the public an explanation so that they can follow the debate taking place in the public domain and follow also the court proceedings, as I believe that it is of national importance. So a company by the name of ConocoPhillips, a US-based company, obtained an arbitral award against a couple of companies in Venezuela that are state-owned, and this award relates to the nationalization by the Venezuelan government and the Venezuelan public corporations of operations of this company called ConocoPhillips. And ConocoPhillips obviously feels that they were wronged. So they took the matter to an international arbitration center, and they got an arbitral award against Venezuela to the tune of millions of US dollars, if not billions. And they have been going around the world seeking to register this arbitral award in various countries where Venezuela is owed a debt, and they have been allowed to essentially enforce this award against monies that are owed to Venezuela by various countries. This process is sanctioned and permitted by an international convention that many countries have entered into, including Guyana, and also by the local laws of the individual territories, which allow for the registration of a foreign arbitral award and its enforcement. In the international convention to which I'm referring, and in all these what are called municipal laws of the different countries, there is a provision, and it's common across the globe, and the provision is that a court will not register a foreign arbitral award if it is contrary to the national policy of the country in which the court is sitting. Let me repeat that. All these laws have a provision in it that prohibits the registration of a foreign award in a country if to do so is contrary to the public policy of that country. So apparently this arbitral award has been registered in Jamaica, in the United Kingdom, in Hong Kong, in Trinidad and Tobago, to name a few. And ConocoPhillips has now come to Guyana to register this award in order to enforce it against certain monies which they claim Guyana owes Venezuela, and these monies are in the national accounts of Guyana as debts to Venezuela. All of this are uncontested. Now, the court obviously now in Guyana must determine whether to enforce this award, to register this award and enforce it, would contravene the public policy of Guyana. Because the law says, the Arbitration Act of Guyana says, as the other arbitration legislation in the various countries say, that if to register this arbitral award in Guyana is contrary to the public policy of Guyana, then the court should not register this award. The issue is as simple as that. So the issue is registration and enforcement of this foreign award contrary to the public policy of Guyana? Because if it is, then the court should not register it. So those were the proceedings that were filed by ConocoPhillips to register this foreign award. The Attorney General was not made a party by ConocoPhillips. So we did not even know about the existence of the proceedings. The learned judge who was hearing the matter, Justice Gino Passad, determined on his own volition that the Attorney General should be made a party and should be heard in the case. Let me repeat that, because that issue is not yet out in the public domain. It is the judge who on his own volition decided to invite the Attorney General to become a party to the proceedings. Now, you tell me, if that judge did not decide by himself that this thing may be against public policy, and therefore I should hear the state, or I should hear the Attorney General, and that is why he invited the Attorney General to be part. Why else would he have invited the Attorney General to be part of the proceedings if the court itself did not determine that there may be national interest issues and public policy issues here? And that is exactly what the court did, invited the Attorney General to be part of the proceedings and to file an affidavit and file written submissions. I was in my corner. It is the court that invited me to be part of it, because I suspect, and it's reasonable for you to infer, that the court itself felt that there was a need to hear the Attorney General. And you must ask yourself why. But let's move on. So, in our affidavit and in our written submissions, the first point, which was made abundantly clear, was this: in the ordinary course of things, the state would pay no interest, would have no objection to the registration and enforcement of a foreign award within the jurisdiction of Guyana. That was the first point that I made. In the ordinary course of things, in an ordinary case involving any ordinary party, we would not have objected. We would not have even been interested. However, there is nothing ordinary about this award. As I explained, this award seeks to take monies by an American company that Guyana owes to Venezuela. Now, one can't look at this situation in isolation and in abstract. It must be contextualized. Does Guyana and Venezuela have normal relations? Is Guyana the same place with Venezuela as Trinidad is? Is Guyana in a same place with Venezuela as Hong Kong is? As Guyana in a same place with Venezuela as Jamaica is? The answer is no. Guyana is virtually at war with Venezuela, instigated by Venezuela due to a territorial claim by Venezuela of 2/3 of Guyana's national territory. And it's not merely a claim, it's a claim that Venezuela is actively enforcing. And how? They have threatened to invade. They have passed a law that that Essequibo belongs to them. They have carried out a referendum in which they have named that part of Guyana, Venezuela, and they want to come to register all the citizens of Essequibo as Venezuelans. All of that have happened. That's not enough. We have a case at the International Court of Justice where we had to rush to get an interim order against Venezuela, restraining them from effecting the referendum or executing the referendum or taking actions under the referendum. The International Court of Justice granted an injunction to that effect. It also injuncted Guyana and Venezuela from taking any steps to aggravate, any steps that would aggravate the situation. It prohibits the International Court of Justice by an interim measure, prohibit Guyana and Venezuela from taking any steps that would aggravate the relationship between the two countries. Then, in addition to that, we went to an agreement, to an engagement brokered by CARICOM in Argyle, St. Vincent, where President Maduro and President Irfan Ali executed a declaration that they signed. And among the things that they agreed to, that neither side would take any steps that would be perceived as being provocative and that would further damage the relations between the parties. Now, while all of this is going on, the Maduro administration has been constantly misreading and misconstruing actions in Guyana as provocative. So when we were in St. Vincent, Mr. Maduro walked with a stack of newspapers that contained articles that Guyanese are writing, criticizing the oil and gas sector and commenting adversely against the government and making all kinds of allegations. And Mr. Maduro, wrongly, but he's doing it, is misconstruing all of these articles as acts of provocation and acts of aggression. The Venezuelan government is on public record as accusing Guyana of being in bed with the U.S. government and the U.S. Army, encouraging them to be in Guyana to provoke Venezuela. They have said that the oil contract itself is a provocative act because it's to bring American investment into the country and into the disputed territory. President Ali visited Essequibo some time ago and had on some outfit. President Maduro made a public statement that that outfit looked like a military fatigue, and that President Ali is on the disputed territory of Essequibo in a military fatigue, and that is provoking a response from Venezuela. And I can go on to give you more and more examples. Against that backdrop, against that factual matrix, whether President Maduro and the Venezuelan government is right or wrong in the perception that they hold those perceptions, and they have made it public. In that volatile environment, how do you think the Venezuelan government will view a court in Guyana permitting an American company to take away money that Guyana owes to Venezuela? And a court of Guyana is doing it, and the government sits idly by and does nothing. How you think that will look to Venezuela or to any objective bystander? And let me come to the crux of the matter. Is it in the best interest of the public policy of Guyana for such an act to take place? Is it not contrary to the public policy of Guyana, having regard to its national security, having regard to its national sovereignty, having regard to everything that I have said? Is it not against the national policy of our country to permit the registration and enforcement of that award against Venezuela's debt in Guyana? Of course it is. And who determines what the national policy is? Now, the law is not unsettled or controversial on this matter. Who determines the national policy of a country is the executive and not the judiciary. So in matters of national security, national interest, the public interest, national policy, the executive determines that. And once the executive determines that something is against the national policy or the national interest, and it is before a court, the executive needs to report that to the court, and the court ought to accept that and decline jurisdiction. That is how civilized nations behave. And that is international law. Because the state of Guyana is indivisible. You can't have a judiciary moving in one direction and a legislature going in another direction. And on this particular matter, the legislature, the parliament of the country, comprising of all the elected representatives of the people, including the executive, the parliament, the elected representatives, the people have spoken in one voice in the parliament, and they pass a motion. And that says that we must stand together on this issue, and we must do nothing that will jeopardize our interest. The judiciary can't be a standalone. These are not matters for the judiciary. These are matters for the executive and the people of the country. And the executive is speaking, and the people have already spoken to their elected representatives in the National Assembly. Now, unless what the executive determines to be public policy is irrational, is ridiculous, is preposterous, and therefore no reasonable government would say that that is national policy, that it is so irrational that no rational, reasonable government will say that that is national policy, then the judiciary cannot question the executive on the matter. It can question the executive if what the executive says is national policy is so irrational that no reasonable person will accept it as national policy. Are you telling me that what I am reporting here to you is so irrational that what I am reporting to you is so preposterous that it cannot be the national policy of Guyana? That it cannot be the national policy of any country? And that is what this debate is about. That is what this debate is about. I see people writing in the newspapers to say that I am determining what is national policy. The truth of the matter is, the CCJ, the Caribbean Court of Justice, only last month, in the case of the Attorney General against the Environmental Protection Agency, Frederick Collins and White against Esso Exploration Production, a case, the CCJ determined that just last week, and they said this: the Attorney General of Guyana performs a constitutional role as the legal advisor of the state and the guardian of the public interest. The public interest may include different facets. Not me saying so. President Adrian Sanders of the CCJ saying that. The Attorney General is a guardian of the public interest. The public interest may include many facets. The public interest includes the public policy of the country. It's not Anil Nandlall is the guardian. The Attorney General is the guardian, whoever it is. And it is the executive branch of government that determines national policy. Not PPPC, as I see people are saying, the PPP determine what national policy. It is the government of the day. If it is the PNC, is the government, they are the determinant of public policy, not the judiciary. And you know why that is so? Because if anything goes wrong, it is the executive that has to answer for national security of this country. It is the executive that has to answer for the national sovereignty of this country. You ever see any judge of Guyana at the ICJ? No. You see the government with the lawyers there. You think any one of the judges of the High Court will go to the ICJ if the judiciary of Guyana breaches the orders of the ICJ? No, they will not go. It is the executive that is answerable. If a wrong is committed, an error is committed in this issue or on this issue of our national sovereignty, you think anybody holding the executive responsible? The people of Guyana will hold the judiciary responsible, sorry. The people of Guyana will hold the executive responsible because it is the executive responsibility. That executive will lose the next elections. The judges will be there because they have security of tenure. And that is why the separation of powers doctrine is constructed in the way that it is. What is your responsibility is yours. The executive can't tell the judiciary how to determine a case. The judiciary in the same way can't tell the executive what is national policy. And when you say these things, you're accused of veiled threats to the judiciary. And you are actually saying the law. If I am telling you that you have no power to do what you want to do, I am threatening your independence. Let me give you a frightening example of what I'm speaking about. Let me give you a frightening example of what I'm speaking about. Let us accept that the judiciary is independent, and it is. It is. The judiciary is independent. Are you telling me, before I get there, so the judiciary can determine any case that comes before it because it's independent? Okay? Let's accept that general proposition. Suppose a citizen of Guyana, a misguided soul, files a case tomorrow in the High Court asking for a declaration that the claim by Venezuela to two-thirds of Guyana's territory is lawful, just, and well-founded. Can the judiciary, in the exercise of its independence, grant those orders? Can the judiciary, in the exercise of its independence, grant those orders? These are the type of discussions that we have to have. This is the type of mental interrogation one has to do of the issues so that you get clear pictures of what is independence of the judiciary and what is not. In the exercise of the independence, are you telling me that the judiciary can grant that order? Can it? So I thought that I'll dwell on this matter so that you, the public, understand. Because Guyana belongs to you. And the test is not what the judiciary thinks national policy is. The test is what the ordinary Guyanese would view as national policy. That is the test. And that test is, that threshold is determined by the executive. And that is not a position in Guyana alone. That is the position all over the world. And that is why an American lawyer by the name of Vivian Williams wrote a beautiful article that was published by the Marara Waves, where he articulated the principles. And you know what he said in that article? In cases like this, in the US, the Attorney General tenders a letter, not submissions, not affidavits. He tenders a letter to the court and says that this, if you move in this direction, it would be contrary to the national policy of the United States of America. And that is the end of the matter. The Supreme Court or the judge, wherever he is sitting, stops. Stop hearing the matter completely. Because that final determination lies with the executive. Unless, as I said, it's a completely irrational assertion coming from the executive. So we need to understand that it's my duty. As the CCJ said, I am the guardian of the public interest. It is my duty to inform you. Because you are the public interest. You are the public. It's your interest that I am the guardian of. And it is my duty, therefore, to explain these things to you. Because the misinformation that's coming from a few can mislead you or can obfuscate the facts, and you can be kept in the dark. You must be educated. Knowledge is power. And that's one of the purpose of this program. And as I am on it, let me deal with it one time. Guess who's the lawyer appearing for ConocoPhillips? This ConocoPhillips is seeking to take actions and has taken actions because they have succeeded through the judgment of the High Court already to act against the national interest of this country. That's what the executive is saying. That's against the national interest of Guyana, against the public policy of Guyana. And take one wild guess who the lawyer is appearing for ConocoPhillips. You can guess by now. Mr. Conflict of Interest himself, Nigel Hughes. Of all the lawyers in this country, ConocoPhillips couldn't find nobody else. And nobody else would have appeared in this matter. But the man who is the conflict himself, Nigel Hughes. He could have declined again. Last week I spent 1 hour dealing with conflict of interest. 1 hour. Where you put on what conflict of interest, what the rules are against conflict of interest. Why is conflict of interest bad? Because you are not, politicians and public officials must not look after their private interests over and above the public interests. They must not look after their private financial affairs over and above their constituents. Who is this gentleman constituents? Guyanese. Whose public interest it is? Guyana's public interest. But whose interest he's representing? Conoco interest. Why? Because he's being paid. So you see, his private financial affairs takes priority and precedence over the national interest and the public interest. That, my friend, is the locus classicus of conflict of interest. So you have another example of conflict of interest. And no matter how many umbrellas you share or how many empty bags you share in Upper Mazaruni, that can't help you here. It's better you don't share the umbrella, and you better you don't share the empty bag, but you look after the people's interest. You can't sell out their interest on the one hand, and then you've gone to Kaduku Mountain and giving them an umbrella quietly in a corner. Have you told the people who you're giving the empty bag to and the umbrella to what you are doing to the public interest in Georgetown? No. Did you tell those people that your retainer with ExxonMobil is much more important than their interest? No, you didn't tell them that. You think that you can fool them with an umbrella and an empty bag and tell them better must come. Better should come right there. The bag should be filled. You cannot give people empty bag and then tell them better must come. So I thought that I'd spend some time dealing with that matter, but I've spent a lot of time already. A lot of attention has been received in the press and a lot of publications I have read in relation to the regulations that were made under the excise tax, in relation to the increase in taxes, in excise tax on certain types of vehicles in relation to remigrants. And I've seen all manner of publications in the social media as well as in the print and formal media. Let me explain to you what has happened. So last year, I believe it was September 2023, the 1st of September 2023, the Guyana Revenue Authority decided that they will increase the excise tax on this class of vehicles and in relation to this category of vehicles. And they implemented the increase on the 1st of September 2023. They implemented it and they were collecting it. But through some inadvertence, they did not promulgate the regulation necessary to increase it, to increase the rates, the tax rates, as they were required to do by the law. You can't have taxation without regulation or legislation. So the decision was made to increase, and they were levying the increase, but they did not, through some inadvertence or error, they did not promulgate the relevant excise regulations. So when it was discovered, and there was a court ruling, they decided to correct the loophole or the lacuna, and that is what they did. And the Interpretation and General Clauses Act allows for retroactive subsidiary legislation. It allows for that. Section 21 of the Act, read it. It says that subsidiary legislation, 21(3), subsidiary legislation may be made to operate retrospectively to any date which is not earlier than coming into operation of the act under which the subsidiary legislation is made. So the act is the Excise Act. Of course, that was passed a long time ago. The regulation can be made today, but be made to operate retroactively to a date prior to today's date. But no one, the GRA is not collecting taxes retroactively. The taxes have already been collected. It is not that you would have cleared your car in October last year and you didn't pay this increase. You paid it. It just did not have legal coverage. It's not that the GRA will now go and check their record and charge everyone who cleared their vehicles from September last year to now and charge them additional fees or additional excise tax. That is not the intention, and that was explained. And also the person who won the case in the court, that person will also not suffer because he won the case. He will not be imposed with this. So no one will be penalized. No one will have to pay extra. But of course, the same gentleman, Nigel Hughes, is the one who misled by speaking about this and saying that it is retroactively levying taxes on people. The same way that he couldn't understand, and he misled the PNC and the AFC and APNU when he told them that 33 is not a majority of 65. Remember, he told them that? He couldn't understand that 33 is a majority of 65. It is in the same way that he misunderstood this provision in the law, and he made misleading statements about retroactive taxation. It is not retroactive taxation. It is legalizing something that was in error, not legal, because the statutory coverage was not there. And the law recognizes that such mistakes can be made. And that is why the law allows for you to pass the regulation and make it retroactive to a day prior to the day that it takes effect. And for the journalists who are listening to me, please consult the Interpretation and General Clauses Act, Chapter 2:01, Section 21, in particular Section 21, subsection 3. So let me repeat. No one will be requested to pay any additional monies who clear their vehicle from September last year to now. They have already paid it. They did not know, however, that the law was not in place for the GRA to charge it. And that's an error that has been now corrected. You see how people can mislead the public? That is what happens on a regular basis in this country. I am quickly running out of time, but let me see what. So let me speak briefly about a very interesting editorial that I've read in the Stabroek News. I may have my problems with the Stabroek News, but I give credit where I think credit is due. And yesterday, Stabroek News editorial dealt with a very important issue, and I want to take this opportunity to say that it was a good editorial, and I want to make a few comments on the editorial. First of all, the editorial rejects this argument that is being put forward for biometrics. The editorial speaks to the mechanisms that are already in place that can guarantee and that have guaranteed fair and transparent polling on elections day. It quoted GCOM as listing those safeguards, and there are many. You know about them. The presence of party agents at polling station, the accurate identification of the voter, the use of the indelible ink, the presence of police personnel, the conduct of an intensive voters' education, counting of ballots at the place of poll, the presence of local and international observers, the posting of the results at the end of the count, etc. Those are not safeguards that one can penetrate. But those who can't win in elections, they're clamoring for biometrics and all sorts of things. You have biometrics already. Your ID card with your photograph, with your distinguishing mark, with all the particulars, those are biometrics. They want tricks. They want an ability to play tricks with elections. They want to put a system that possibly they can manipulate. And as the editorial points out, this system worked on election day. So much so that all the international observers and national observers, all the political parties, including APNU AFC, reported that voting went well. The polling day staff discharged their functions with distinction. There was not an incident of any magnitude at the end of poll. None reported. It is after when a few in the secretariat at GCOM attempted to perpetrate that grand robbery at Ashmin's building. And that is the problem. It is the GCOM staff, and the editorial highlights that. The GCOM staff in the secretariat that sought to hijack the process by using spreadsheets and bed sheets instead of statements of poll. That is what caused the problem. But What I want to point out is that the editorial of Stabrook News omitted two important dimensions. One, it did not utter a word about those in the political arena who were aiding and abetting those in the Secretariat performing the skullduggery at Ashbin's building. You had leaders of the APNU, AFC, who were actively aiding and abetting both outside the building and inside the building. They were sending WhatsApp messages, they were sending, and they were in the building. But I didn't see that here. That should be written to Mr. Editor of Stabrook News. And the role that the GCOM commissioners played as well. And I'm going to deal with that separately. And I also would like for the editor of Stabrook News to speak to the very persons whom they have identified as the electoral culprits at Ashbin's building. I would like the editor of Stabrook News to speak about the hurdles that the state is facing in attempting to bring these people to justice. These are the very people who are charged and before the magistrates' court. And the public is well aware of the monumental challenges that the state is encountering in ensuring that these people are brought to justice. Stabrook News need to do an editorial about what is going on in the magistrates' court. And that brings me to the commissioner, because Stabrook News spoke about the chair of GCOM and very critical of the chair of GCOM. And I'm not here to defend the chair of GCOM. I want to speak to the staff itself, and we are saying, and I have always said, that GCOM must ensure that they hire staff of integrity. They must hire staff with integrity, trained, qualified people, people whose character and reputation can withstand scrutiny and who are not prone to the proclivities we have seen exhibited by those who were manning the operations in Ashbin's building. And we have also said that the composition of the staff must represent the voting demographic of the country as well. Currently, it does not. And that's an important factor in the electoral equation of this country. But I want to get to Vincent Alexander, because someone sent me a clip, and he was regaling somebody interviewing him on Facebook about 15,000 persons who apparently impersonated voters and voted and who were not supposed to vote. Now, it means that 15,000 fraudulent ballots were cast. 15,000. First of all, if Vincent Alexander as a commissioner has presided over an election that 15,000 fraudsters cast their ballots, what is he still doing there as an election commissioner? Should he not resign? If he is admitting that he presided over a system where 15,000 fraudulent ballots were cast, why is he still there? He should resign. The PNC or whoever has put him there must recall him. He's a complete and utter waste of time. He's totally incompetent and should not be paid from the public treasury. Because he's telling us that 15,000 fraudulent voters voted. And he's running the elections. And he's still there. But let me tell you how ridiculous it is. 15,000 persons. You know the Guyana National Stadium? When we have a cricket match and it is packed to capacity, it's just about 12,000 persons. When the National Stadium is packed to capacity, that's 12,000 persons only, or possibly less. 15,000 is 3,000 more than what you see in the National Stadium. You could imagine when the stadium, when the cricket match finish, how many people you see? As far as your eyes can see, you're seeing people pouring out of the stadium. That's only 12,000. Well, 15,000 of those were on the streets election day and voted. And Alexander didn't see any. APNU, AFC didn't see any. None of their polling agents didn't see any. None of the police that at the polling station didn't see any. None of the international or local observers didn't see any. 15,000 people. And they're repeating that madness up to now. They are repeating that madness up to now. Anyway, as usual, I have run out of time. Every time I say that I'm going to look and get your comments and engage you in discussions, I run out of time. I am so sorry. So I want to thank you very much for spending the past hour with me. Again, we have covered great depth, and I hope that I have explained some important issues for you. I want to thank you once again, and please enjoy the rest of your evening tonight, and I'll see you next week. Take care, stay in good health and in good shape until we meet again next week. Thank you very much and take care.